Well, thank you again, everybody, for having me. I'm going to go over a regulatory overview of cannabis and hemp regulations in the state of Florida with a little bit of federal law overlay on that as well. If you have questions at the end, I'm happy to answer them. If there's anything I haven't answered, more than happy to talk to you offline about that as well. So the fun legal disclaimer that I give to everybody when I do any of these presentations is that marijuana is illegal under federal law and could land you in jail with all of your assets frozen. That's the exact legal disclaimer that I give to all of my clients when I engage them at the firm. And interestingly enough, it's a legal disclaimer that nobody seems to balk at, because if you're going to be involved in the cannabis industry in the United States, you have to have an understanding that it is de facto illegal on a federal level unless and until federal law changes. So why is marijuana illegal under federal law? Well, the very simple answer is because the Controlled Substances Act says so. The Controlled Substances Act is a piece of federal legislation that gives basically a ranking of the types of drugs that we have and how you can produce them, manufacture them, and distribute them throughout the United States. So Schedule 1 through 5 drugs are the way that we have controlled substances regulated in the United States. So Schedule 1 drugs are actually the ones you don't want to be, because those are drugs that the federal government has deemed to basically have no accepted medical use and a very high potential for abuse. Some of those drugs are things like heroin, LSD, ecstasy, peyote, and marijuana, which most people find confusing because you would think of hard street drugs like heroin and LSD to be some fundamentally different than you would think of things like marijuana. You also don't see a majority of the states enacting programs to legalize heroin for medicinal use. Interestingly enough, one of the drugs that's left off of Schedule 1 is cocaine, which means in the United States, cocaine has been deemed to have more medical benefits and be less addictive and less likely to be abused than marijuana. So I want to talk about cannabis and hemp because there's a difference between the two of them, and that difference is also impactful to the real estate industry as well as just the economy in general. So when we talk about hemp and cannabis, some people use the terms interchangeably. Well, both hemp and marijuana come from the Cannabis sativa L plant. So if you were to look at the two plants, unless it's basically an industrial hemp plant, for the most part, they all look exactly the same, which makes it very difficult for law enforcement to know whether you are smoking hemp or you're smoking marijuana. So that's causing a lot of problems on the criminal side in the state of Florida. But when it comes to the actual compounds of the plant, the only distinction between the two is just a construct from the federal government that created a delineation on the amount of THC that is inside the plant. And if you're pretending like you don't know what THC is, that's the part of the plant that gets you high. So everybody sees marijuana as being predominantly for recreational uses, but it also has a lot of medical uses around the United States as well. And globally, there are a lot of other countries that have very strong uses of medical marijuana and have for a very long time. Hemp, however, in the United States has just recently in 2018 under the Farm Bill has come to fruition as being legalized on a much broader level for broad agricultural purposes. So hemp now is a Cannabis sativa L plant that has less than 0.3% THC. So if you're a farmer and you are cultivating hemp, you could be growing hemp today, and next week you're
Hey, hold hands, please. Ready? Hold hands. Thank you. Bye.
Hello? Okay, sorry, I don't know what that feedback was, but hopefully, is everybody hearing it okay now? If I could get a thumbs up from anybody? Yes? Okay. Looks like, thank you. Okay, perfect. So the hemp plant itself has more than 0.3% THC, and it has a range of uses above and beyond what the cannabis plant has. So hemp is used for things like medical, industrial, textiles, food, personal care, construction, animal feed, etc. Interestingly enough, Henry Ford actually made a car that was out of the hemp fibers. So hemp fiber is as strong as steel. You can make houses out of hempcrete. So it is a replacement for many of the commodities that we currently have on the market. And I think you're going to see in the next 5 to 10 years that hemp is going to become a replacement for many of the things that we each use day in and day out. The 2018 Farm Bill removed hemp as a Schedule 1 drug. So prior to the 2018 Farm Bill, hemp was actually treated the same as marijuana on a federal level. Even though nobody was smoking hemp to get high, federal government still treated it all the same. So now hemp is no longer a controlled substance, but keep in mind, that is assuming the plant has less than 0.3% THC. States and Indian tribes can't prohibit interstate transportation of hemp, which is a huge difference between hemp and cannabis. Cannabis, even if it is legal within one state, you cannot transport it between states because you will absolutely be in violation of federal law and put yourself in danger of federal prosecution. Now, most of my clients who sign that waiver that says what you are doing is illegal under federal law, you could go to jail, you could get your assets frozen, it really doesn't apply. No one's going to jail unless they do what I call additional stupid things, which are not paying your taxes, transporting between state lines, or breaking other other laws in the process. In addition, the Farm Bill. Sorry, I think if everybody could mute, I don't know if somebody unmuted their computer. Jerry, I think you're on the. I don't know, Angela, if you're able to mute Jerry. I don't know if he knows that. Oh, I just muted him. We're good. Okay. So the Farm Bill does not alter or modify the authority of the Secretary of Human Services or Food and Drugs from promulgating regulations. And that's something that we'll touch on briefly because there's a lot of confusion when it comes to CBD products and CBD that comes from marijuana versus CBD that comes from hemp. So CBD is CBD. It is the same molecule if it comes from hemp versus marijuana, same for THC. But if it comes from the hemp plant, the CBD is legal in some senses. If it comes from the marijuana plant under federal law, it's illegal, but depending on the state, it could be legal. So under Florida Bill SB 1020, our program for hemp came about and allowed for a very broad agricultural program to be started in the state of Florida. So we have a ton of different regulations. I'm not going to go into these in too much detail, but I have a lot of questions for people who want to sell hemp seeds or they want to grow hemp. But in the state of Florida, we have very specific regulations on the use of hemp seeds. Basically, you can only use certified seeds in the state, and you can only distribute hemp if there is a certificate of analysis prepared by an independent lab. You have to have it tested, and you have to have a product of a batch that's been tested, has to have that less than 0.3% THC, safe for human consumption. And the Florida Department of Agriculture and Consumer Services oversees the hemp industry, and they conduct random inspections. In addition, there's regulations. This should just make you feel good that if you get hemp that has been produced in the state of Florida in compliance with Florida law, that it should be safe for human consumption. And all of these types of markers should be on a hemp label to ensure that it is in fact tested and safe for human consumption. Moreover, the Division of Plant Industry oversees cultivation in the state. Under FDAC's food safety oversees processing and manufacturing, and Division of Ag oversees obviously things like fertilizer, animal feed. So can you plant hemp now? If one of you is interested, the answer is yes. Permit applications started 4/27/20. They really wanted them to come out on 4/20/20, but they weren't able to make that happen. And hemp can be planted indoors or outdoors on lands zoned for agricultural or industrial uses. So if you get anybody who wants to grow hemp inside their house, that's probably not going to be allowed unless they are in a land zoned for ag or industrial use. So should you buy CBD from gas stations? I don't buy my wellness products from gas stations, I guess, unless sugar-free Red Bull counts. But I always say buyer beware. Many CBD products that are currently being sold are unregulated and without standards. So you really want to make sure that if you're buying them, that they have been produced in a state, come from a state that has proper regulations in place. Our state food permitting requirements are helping to stop bad actors, and a lot of things have been taken off the shelf. It's pretty alarming because the state found within the last year that some of the products that were on the shelf that weren't being tested before had really high levels of things like lead and arsenic in them. I mean, toxic levels of them. So thankfully, FDACS is doing a good job of regulating that. Now, the FDA has separate enforcement authority. So Florida Department of Ag has some authority. The FDA has separate authority, especially if you're putting those hemp CBD products into the chain of commerce. So let's talk about some FDA considerations, just as a fun fact in case you go to hemp trivia at any time. And back in 2018, the FDA actually approved a drug called Epidiolex to treat very rare seizure disorders. And that drug is derived from the hemp plant. So it takes CBD from marijuana and put it into a drug that the federal government approved. Now, if you think about that, it doesn't make any sense because we just told you that a Schedule I drug, marijuana, is illegal because it's deemed to have no medical use, yet the FDA has approved a drug called Epidiolex that comes directly from marijuana. Moreover, when it comes to regulation of CBD, the FDA basically uses enforcement discretion to regulate CBD products. If you want to have an in-depth conversation about this, I am more than happy because there are a lot of regulations about introduction of food products or beauty products or any other types of ingestible products into interstate commerce. If you are marketing them as dietary supplements or anything else and making claims that they have medical benefits or that they are dietary supplements. And the FDA is sending out warning letters to say, you can't do this. And the reason is because now that Epidiolex is an FDA approved drug, if you were to put out CBD products in a lollipop on the market, the FDA essentially sees that as the same as putting out penicillin lollipops, right? Saying, I'm going to put CBD into food products and now sell it at a gas station or a CVS. The FDA wouldn't allow a drug maker to do that with any other antibiotics. And so they're saying, we've approved Epidiolex. Epidiolex is a regulated drug. CBD is therefore a regulated part of a drug, and you cannot put drugs into interstate commerce without approval from the FDA. So it's a bit of a gray area on how the hemp industry is actually being federally regulated now. There is some CBD legislation. A bipartisan bill was filed last year to try to allow for CBD to be added to the definition of a dietary supplement. There's been no movement since then. And also doesn't address whether other hemp cannabinoids would also be regulated as well, because CBD is not the only cannabinoid that comes from hemp. There's about 110, 150, depending on who you ask, other cannabinoids that can be used and have medical and other beneficial purposes from both the hemp and marijuana plant. So where's the United States at with marijuana? Interestingly, but maybe not surprisingly, California was the first state to approve a medical program in 1996. And since then, about 3/4 of US states allow some form of medical marijuana. 15 states permit adult use, meaning recreational, soon to be 16 if the governor signs off soon in Virginia. At least 12 state legislatures have recreational legalization measures on the table right now, which is a pretty typical number for this time of year. Florida has 2 of those bills proposed. We still have a largely conservative hold in our state legislature. So we're probably not going to see any bills for recreational use get approved. If anything, recreational use would probably get approved via a ballot initiative, very similarly to how medical marijuana got approved in Florida under Amendment 2. That ballot initiative didn't make it on for 2020. There is a fight to get it in the 2022 election ballot, if not the 2024 election ballot. Polling shows that it would probably win if it got on the ballot for recreational adult use. The way it was proposed for the last election was that recreational adult use would have only been allowed if that marijuana was created and sold by licensed medical marijuana companies in the state. So it would have been a very regulated industry that allowed adults 21 and up to be able to possess a certain number of ounces of marijuana for any recreational use they please. And so if that were to happen, Florida would probably go gangbusters. We would be one of the largest states for recreational sales, given the number of tourists we had pre-COVID coming into the state every single year. So if we had recreational laws, or if we allowed reciprocity for those out of state to get their medical cards filled when they come to Florida for 6-week vacations, if that starts happening again, Florida would have a huge booming cannabis industry. So a lot of eyes are on Florida, and I can tell you that the medical industry here is very much looking and waiting for it to turn recreational, because that is the long-term play. If you look at any of the states that have started with medical, the analogy is that once the camel gets its nose under the tent, typically then the whole camel is going to get in pretty soon, because they're going to get recreational down the road. That's just the trajectory that all the other states have had. If you look at more mature cannabis markets, you'll see that to be true. So what does the Department of Justice have to say about marijuana? This is not going to surprise you, not fans, right? So back in 2013, there was a little bit of a softer stance that was taken towards cannabis under the Cole Memorandum. The Cole Memorandum had 8 enforcement priorities. Basically, we don't want to get cannabis in the hands of kids. We don't want to get it in the hands of gangs. We don't want to be diverting between states. We don't want to have cannabis companies being used to cover as trafficking or other illegal operations. We want to prevent violence and firearms. We don't want drug driving, and we don't want it on public lands. And we also don't want it in prisons. So basically the federal government didn't want to have these narco style big drug and gang wars happening around the cannabis industry. But they recognize that we don't have enough time to go after all of these states that have legal medical programs in place, even if it's conflicting on face with what's happening on a federal level under Schedule 1 of the Controlled Substances Act. But was this prosecutorial immunity? Absolutely not. If anybody read the 3-page memo that came out in 2013 from the Department of Justice, it was very clear that it was not. And so it created no substantive rights, but it made everybody feel good. And that security blanket was very important, because in January 4th of 2018, Jeff Sessions put out a memo that said, forget what Cole says, prosecute as you please. It's illegal under federal law. And unless that changes, the black letter law says we can put you in jail and prosecute you zealously for any violation of drug laws here in the United States. I will tell you, that was a very bad week for cannabis companies. Stocks plummeted because cannabis companies at the time were only trading on the Canadian Stock Exchange, not on the New York Stock Exchange. And so the Canadian Stock Exchange for those cannabis companies tanked, because everybody and their valuations were tied very largely to what was happening in the United States. A lot of people were pulling out of cannabis deals. Landlords were terminating leases. People didn't want to invest any further. Everybody thought that they were going to get prosecuted. So it was a really good couple of weeks for lawyers and for billable hours for lawyers in the cannabis space, but it was awful for the industry. Ended up bouncing back when everybody realized that there wasn't going to be wholesale prosecutions and just a tsunami of prosecutions nationwide that we assumed there may have been. But we knew this was coming, because Jeff Sessions had said in a congressional testimony previously that good people do not smoke marijuana. The interesting part is, on a federal level, you can still, by you can, I mean, you must still pay taxes, and banks can take your money. I represent banks who do bank this industry, and you still have to pay taxes. So the crazy part is cannabis companies that have to pay their taxes every year. You don't see meth companies or underground crystal meth or, heroin companies paying, these drug dealers paying anything to the federal government in terms of federal income tax, but cannabis companies absolutely have to. That is how you get in trouble if you don't. And those cannabis companies are paying up to 70% sometimes in tax at the end of the year, depending on the state that you're in, when you're paying state, local, and federal taxes, and you get to write off nothing because there is a provision under the IRS code called 280E, which says you can have no normal business deductions as a cannabis company, which is staggering if you think about it. So very slim margins for cannabis companies. It's not just the gold rush that everybody thinks it is. This is irrelevant, but I just thought it was funny. After Sessions put that memo out, people released rolling papers, which again, if you're pretending you don't know what those are how people roll up marijuana and smoke it. And they call them General Jeff Sessions papers. I don't think Jeff Sessions was happy about that, but those sold very well when those hit the market. So real quick on cannabis businesses, and I think this is of interest to anybody who may take on a landlord or a tenant and represent them in the real estate space when it comes to cannabis companies. So if you are going to work with any cannabis companies as clients, one thing to keep in mind is that there are some difficulties in taking in money. It's not impossible, but there are difficulties. And the reason is under FinCEN and under the Bank Secrecy Act. So the BSA basically says we don't want to have any money laundering. Federal government says we want to know what money is going where and that it's not for illegal purposes. So banks can face government seizure by the FDIC if they do business with cannabis companies. Crazy enough, it's estimated that over 70% of cannabis companies do not have a bank, which is really a shame. And FinCEN has issued some guidance in 2014 to try to create some expectations around the regulations for cannabis industries and banks that want to bank cannabis clients. And that guidance was based on the Cole memo, which was rescinded, but yet FinCEN hasn't given any more guidance since then. Small Business Administration loans, you cannot get an SBA loan if you are doing something illegal. So if you're a cannabis company, you are ineligible. Crazy enough, they even say those who are selling smoking devices for marijuana companies are also ineligible. So a very broad net was cast on ineligibility for federal loans. Moreover, they changed in 2019 to update to reflect the 2018 Farm Bill to say that if you are a hemp company, you are eligible so long as you comply with federal law. So hemp banking considerations very different than cannabis. So cannabis companies, when they go to try to get a bank, if you do have any clients, if you are in the cannabis industry, I'm happy to get you in touch with banks that are willing to bank cannabis companies. They have some additional due diligence procedures they have to go through in order to keep cannabis clients, but there are options for banking money here in the state of Florida. And so landlords will often put their lease under a special purpose entity, and that special purpose entity will open up its own bank account, typically not at the landlord's normal bank, because places like Wells Fargo and Bank of America aren't going to bank this industry. And then I have tenants that they obviously work with banks if they're the cannabis company that know that that bank has an exact idea of what they do, which is sell cannabis. So they don't have any issue once they have their bank account opened. Usually, sometimes if banks go through a merger process, that's when you have big problems. And we've had to see millions of dollars getting moved in armored cars throughout the state when some of the original banks that bank the industry did go through that merger and acquisition process and could no longer take cannabis companies. So when it comes to banking for hemp, there's been some joint guidance that's been issued that basically says all the things that banks have to do for hemp companies, you don't have to do. I'm sorry, for cannabis companies, you don't have to do for hemp companies. Banks have discretion. If they want to take hemp companies, they can, but you are responsible as a bank for deducting your own due diligence on any new client. So let's talk about Florida laws on marijuana. So back in 2014, Florida enacted the Compassionate Medical Cannabis Act. The Compassionate Medical Cannabis Act said that low THC marijuana could be recommended. Now, keep in mind, it is a recommendation. It is not a prescription. A lot of times you will hear people say, oh, I have a prescription for marijuana. That is not true. There is no prescription because it is federally illegal, which is why you do not get cannabis inside of a CVS or a Walgreens or a Publix pharmacy. And unless and until federal law changes, you will not see CVS or any of those normal pharmacies distributing cannabis. But back in 2014, recommendations from a licensed physician were allowed for patients who had cancer or chronic seizures and muscle spasms. You had to be seen by a licensed physician for 90 days. Now, if you think about that, I could probably get a prescription right now for heavy narcotics, in 90 seconds if I went to a doctor and told them I had back pain or something else, but you had to see a doctor for 90 days if you were a cancer patient or you had epilepsy. So it was a very strict program in 2014. It created the Compassionate Use Registry, which is essentially a state registry that is making sure you as a patient or you as a doctor are not writing recommendations for the same patient above what is allowed, or that I'm not doctor shopping as a patient and going to get 7 different doctors to all write me recommendations so I can fill those recommendations and get 7 times the amount I would otherwise be allowed under the law. So the same use registry system is similar to what they had to fight the opioid epidemic here in Florida. And so that keeps that tracking in place. It's a vertically integrated system, and this is important for understanding the Florida medical market, which is very different than what a lot of other states have. Vertical integration means that if I am a cannabis company in the state of Florida that is licensed, I have to cultivate the cannabis myself indoors, has to be fully indoors and secured. I have to then process that cannabis down into an end product. At the time, it was only refined oil products. Now it's smokable and some others, but you have to process it down into an end product, all under the same umbrella of that company. You are then responsible for transporting that product in secured vehicles, either to patients for at-home patient delivery or to dispensaries via that same delivery system, to a brick and mortar dispensary for you to be able to dispense to patients that way as well. So each company had to do all of those aspects, hence why it's called vertical integration, and they were responsible for every step of that supply chain and could not contract out for third parties. Keep in mind too that that means if I am a company, for example, if I am Liberty Health Sciences or I am VitaCan or MedMen or TrueLeave, I can only sell the product that I grow in the state of Florida within the state of Florida to my dispensaries in the state of Florida. So if you go to a dispensary for TrueLeave, you are buying TrueLeave's products or the products they have licensed from a brand name and they create themselves. You cannot get any of the other cannabis companies' products inside. So that's one of the different aspects of our program. Whereas if you go to a Colorado, not saying that you have, but if you did and went to a dispensary out there, you would see that it's basically like a candy store that carries Hershey's and Snickers and every other kind of cannabis product out there and their equivalents, because they are able to retail a wide variety. Whereas in Florida, we do not allow that. In 2015, the Right to Try Act was enacted in Florida that said that medical marijuana patients could get low and high THC product for terminally ill patients. You had to have 2 physicians determine that you were terminally ill, meaning you had less than 1 year to live, to get access to a 45-day supply. In 2016, if you missed it, we had Amendment 2. Amendment 2 made the use of medical marijuana legal. It expanded the definition of qualifying medical conditions, and it established MMTCs, which are medical marijuana treatment. MMTCs are basically exactly the same, and those MMTCs are the same as the companies that had existed before. They just rebranded what we call MMTCs here. When it comes to regulations after Amendment 2, the regulation said that by October 3rd, 2017, the Department of Health was supposed to issue 10 new licenses. Something to keep in mind is that in the state of Florida, in the beginning of the program, we only had 5 applicants who won through a competitive application process. We now have 22 licensed companies. And the reason we have 22 companies is because 17 companies won cannabis licenses in the state by suing the state. So if in case you couldn't figure out what the best strategy to get a license in the state of Florida was, suing the state of Florida was absolutely hands down the best way to get a license after 2015 if you didn't win in that first round of a competitive application process. That competitive application process drew a lot of litigation. And there were judges who issued rulings that literally said in the ruling that the scoring process and the application process was a, quote, dumpster fire. So it was a very contentious application process, a very contentious implementation of a program, and it has been since day one, and it still continues to be. Now, the state also had regulations that said once that compassionate use registry hit 100,000 active patients, that the Department of Health may issue more licenses, but they still haven't. And so there's current litigation before the Florida Supreme Court on the constitutionality of that vertically integrated requirement that I talked about. So it's unclear what's going to happen. If the Supreme Court says vertical integration is unconstitutional, that means we might have a program that is now going to allow for horizontal integration, which could be that I'm able to get a license just to cultivate. Angela can get a license to dispense. Jerry can get a license to be a processor. Anybody on this call could get one of those many licenses in the state of Florida for part of the cannabis industry. You don't have to be involved in every aspect of the cannabis industry, but it's unclear whether that's going to be the outcome of that case. Or the Supreme Court could say vertical integration is okay. It has a tie to public policy, health, safety, welfare. We believe it's constitutional, and therefore that tight grip on the system is going to remain. One thing that's interesting about the state of Florida why a lot of people are looking at our market is because it is such a limited market right now. We have such a monopoly of 22 companies that is so fundamentally different. I think Oklahoma has like 4,500 licenses in the cannabis industry, which I'm not sure how that equates to it per person in the population, but 4,500 licenses is an astronomical number based on the size of their market versus what we have here in the state of Florida. Now, there's different delivery devices and routes of administration. Things like vaping are allowed, edibles are allowed, and smoking is allowed under SB 182. Qualifying conditions for medical cannabis patients: cancer, epilepsy, glaucoma, HIV, AIDS, PTSD, ALS, Crohn's, Parkinson's, and AS. A terminal condition that is caused, a terminal condition, as we described before, that a physician says that they agree with, chronic non-malignant pain caused by one of those underlying conditions, or medical conditions of the same kind or class. So basically, some latitude is given to physicians to say, this is a comparable medical condition to the other ones enumerated under statutes, and you are able to get a recommendation for cannabis if a licensed physician deems it to be true. Edibles in the state of Florida. So we really just had an edible market start in the state. Even though our rules contemplated that edibles were allowed, companies really weren't able to produce edibles because the Department of Health hadn't promulgated their rules, and the Florida Department of Agriculture and Consumer Services also hadn't promulgated their rules. So up until last summer, we hadn't had any regulations out, but FDACS now requires that you get a permit to operate under food safety rules if you want to make edibles under a medical marijuana treatment center license here in the state of Florida. Remember, still vertically integrated, so the MMTCs are making all of their edibles in-house. Under the rules, edibles can't be attractive to kids. I always find that one very interesting because kids put like batteries in their mouth. So I'm not sure what isn't going to be attractive to kids when it's an edible, but can't be attractive to kids, can't be in the shape of people, cartoons, or animals, be manufactured in a form that bears any resemblance to anything available for consumption as commercially available candy. That's ridiculously broad as well. And cannot contain any color additives. So if you think that this looks like the least fun edibles in America, you are probably right. I think that this is what edibles could look like if they followed the very strict requirements under Florida law. Gelatinous, colorless, pretty disgusting looking is the only way to really fit in those parameters. But here's a whole list of edibles that are not permitted in the state of Florida based on those regulations. You are not going to get stuff like Pop-Tarts, which, by the way, these things that are actually put out on market are such blatant intellectual property violations. I can tell you Kellogg's does not make Pop-Tarts, right? And they are not happy that Pop-Tarts is out on the market. And you will see cease and desist letters that come out from some of these very large food manufacturers that are telling these marijuana companies, like, you've got to stop putting our name just literally on your products. And you've got to stop knocking our products' branding and logos off. We don't make these. And then the pot companies are like, we're going to make a ton of money even while you sue us. So we're still going to keep them on the market until we basically are told by a judge not to. You're probably not going to see Keef Cat bars in Florida, ring pots, probably won't see Buddha fingers, ganja joys. Here's some good breakfast options of Cap and Munch, Chronic Toast Crunch, or Fruity Loops. I think it'd be really fun to work in the marketing department of one of these cannabis companies for like a week, just because of how ridiculous the products are that they make. You can get your Klondike bars, Reefer's Medicated Peanut Butter by Cannabis. I mean, I think that's clever. So a lot of these are just really clever in my opinion. Again, they make a boatload of money in recreational markets. Cap and Chronic is another delightful way to start your day. Fruit Poofs, also apparently a great thing to wake and bake. Weedos, flaming hot weed Cheetos. I mean, if you have eaten something, by the way, you can put marijuana in it, is what the lesson is from this slide. Stony Patch Kids, I always like those. Those actually were mandated to be taken off the shelf by a judge. The company that puts out Sour Patch Kids won, hands down, without a doubt what they were going to win, because this is the most ridiculous knockoff. I always did appreciate the little one red stoned eye. It has a little bloodshot eye on those little characters. Very clever. And then Dank Kush Oreos, again, not made by Nabisco, not made by Oreo at all. But this is, and then Nugtella, hazelnut spread with medical marijuana. So lots of options if you are hungry in California or Colorado. And then maybe you can get some Dankies, which are 1,000 milligram weed Twinkies. So why no fun edibles in the state of Florida? Well, one, because we don't want, basically we have a state that's not allowing it as a recreational market. So we want it to be medical, but you have things happen like high school teacher, accidentally eats weed brownies that were given to them by their student. I question how accidental that was. Fifth grader mistakenly was giving out pot candy to their classmates at school. Now, spoiler alert, nothing bad happened to the kids, so it's okay to laugh. But that fifth grader got that candy from her grandfather on accident and then gave it out at recess, and that caused some confusion for the nurse. Vermont hotel employees hospitalized after accidentally eating marijuana candies. To me, that's on you. If you eat candy you find in a hotel room, I mean, you kind of are taking the risk of whatever's going to happen to you. But the real reason that we don't want, fun edibles in the state of Florida is because we don't want kids to get their hands on these, because as you can tell from the last slide, it is indistinguishable, a lot of these products, as to whether they have cannabis in them or not. And we really don't want these getting in the hands of children. So when it comes to medical marijuana in the workplace, something to keep in mind in the state of Florida, that there are really not a lot of protections if you are an employee. So our statutory law very clearly says that regardless of us having a medical marijuana program in the state of Florida, companies can still have a drug-free workplace program or policies. It doesn't matter if you are a patient and you are given a recommendation by a doctor, you still can have your job taken away if you fail a drug test, if your company keeps a drug-free workplace policy. Employers do not have to accommodate the use of marijuana in the workplace. There's no cause of action against an employer for wrongful discharge or discrimination if you are a medical patient. And this also doesn't impair the ability to limit or restrict smoking or vaping marijuana on private property. One of the other things also to keep in mind is that you still have to submit to a breath, blood, urine, or other test to determine the presence of a controlled substance when it comes to certain criminal offenses. And no ADA protections, obviously, right? Because it is illegal under federal law. Cannabis still is. So there's no duty to accommodate under federal law. Under Florida law, it also reflects the same. And that's been upheld under case law as well. So really limited protections for employees who use cannabis with a valid recommendation from a licensed physician in the state of Florida. When it comes to dispensing of marijuana, as of last Friday, now if you are just really interested in marijuana statistics every Friday afternoon, you can go to www.knowthefactsmmj.com. It's the Department of Health Office of Medical Marijuana Use. Every Friday, they put out statistics on the number of patients. Last Friday, it was over 500,000. Sorry, that should be 2,619 licensed physicians as of last Friday, 322 approved dispensing locations. And this gives you some wild stats. So just in that last week period, we had in those across the state of Florida, over 165 million milligrams of high THC product were dispensed. Over 4.1 million milligrams of low THC product were dispensed, and over 57,000 ounces of smokable product were dispensed just last week in the state of Florida. And you can see how that pans out for every single one of those licensed dispensaries in the state. The ones at the very bottom that are not yet in blue, those have not received cultivation or dispensing or processing authorization. So they don't have products yet out on the market. And you can see that some of these companies like The Botanist, Sanctuary, let's see, also Perkins, The Flowery, those have very limited dispensing numbers so far. Because they're new, they had to meet their deadline to be able to dispense, but they probably just haven't opened up enough dispensaries to do it. But watch out for those because they are coming online and probably coming to a location near you. When it comes to where you can put medical marijuana, anything, right? So whether that's cultivation, processing facilities, or dispensaries, under Florida statutory law, there are very clear preemption provisions. And this is actually how I got into the industry back in 2015, was through land use regulations, because I had one of the first licensed companies who needed help opening up dispensaries across the state of Florida. And so under Florida statutory law then, it basically said local governments could determine the number, the location, and other reasonable permitting requirements for dispensaries. And that was it. And it said that everything else was preempted to the state, meaning cultivation and processing are preempted to the state of Florida. That is still the case today. So under statutory law, cultivation facilities and processing facilities by licensed medical marijuana companies are not subject to any local zoning regulations. Now, if you are a zoning lawyer, that both gives you heart palpitations and sort of makes you cheer all at the same time. But it's pretty wild that local governments have no say, which means I could build a processing facility 80 stories high with no parking, no setbacks, as big as I want on a piece of property because zoning regulations don't apply. I still have to comply with Florida Building Code and Florida Fire Safety Code. But if I were to go through plan review with a local government, I would only be going through plan review for Florida Building and Fire Safety Code, not for any zoning code. But when it comes to a local government level of how they can regulate dispensaries, dispensaries can either be banned in a local government, or if a county or city allows them, they have to treat them the same as pharmacies. Now, what that means is if you are going to allow a pharmacy in a, say, for example, C2 commercial zoning district, Well, then if you allow medical marijuana dispensaries, they would also have to be allowed in a C2 zoning district because that's where pharmacies are allowed. So some local governments said we want to allow for dispensaries to come in, but we don't want to allow them anywhere a pharmacy can go, because in some jurisdictions, pharmacies can go basically anywhere. So some local government said, all right, well, we're going to have pharmacies and dispensaries both be located 1,000 feet from a church, 1,000 feet from a school, 1,000 feet from a liquor store and a daycare and a park. And so now regulations on pharmacies have become more strict in certain jurisdictions, just to make sure that we don't have a proliferation of dispensaries everywhere. But for the most part, places like, for example, Orange County, Florida, say you can kind of go wherever in commercial spaces. And then there's markets like Fort Lauderdale, which are very restrictive, and you have to go through a conditional use process that can take a long time and requires you to submit essentially fully engineered construction plans for approval before their planning commission. So anytime you're going to look for a client who's interested in opening up a dispensary, or if you have a piece of property that you think would be great for a dispensary, you want to make sure you look first at local zoning code. Always request a zoning verification letter to ensure that the use is permitted. And something clients are going to want to know is, can they have a drive-through? Because drive-throughs are very popular for cannabis companies. And so they want the capability to have drive-throughs. And there's not a whole lot of magic as to what companies are looking for. They're looking for anything from 1,000 to sometimes 5,000, 6,000 square feet of space. They want it to be in the same locations that you would think a branch bank or any other big high traffic retail user is going to want to be. They're going to want to have good parking, good access, good existing signage rights, good visibility from the road. Those are all things that cannabis companies are also looking for, and in markets with dense populations, and of course in markets where it's already supported and allowed under code. Other times, some companies are looking to get on the closest periphery to big markets that ban it. So around the city of Miami, since the city of Miami outright bans dispensaries, I have a lot of clients that are trying to get in right as close as they can to the boundary of the city of Miami so that they can still serve that market. Keep in mind, local governments cannot stop a company from dispensing through patient delivery at home. So even if a local government says you can't just have a dispensary here physically, they can't stop a company from delivering to my door my recommendation. Some real estate considerations. So the first, standard default provisions. Do not take for granted that your standard contract is going to make sense in the cannabis industry, because I'll tell you, something as simple as the tenant will comply with all local, state, and federal law puts my clients in violation and in breach of the lease the minute they sign it. So we cannot ever use standard provisions in our contracts. I mean, for the most part, boilerplate provisions are okay and they do work, but we have to be very particular about the types of provisions that we have. You want to look at prohibited and permitted uses. I oftentimes am reading declarations of restrictive covenants and trying to determine what the risk level is for my client if we can't get a declaration amended. So for example, there have been declarations that say no pharmacy uses. Well, under state law, local governments have to treat a dispensary as a pharmacy, but that doesn't mean it is a pharmacy, because pharmacies are licensed differently under state law than a medical marijuana dispensary would be. So my argument would be that declaration wouldn't prohibit our use, because we are not a pharmacy, even if a dispensary is treated as a pharmacy by virtue of statutory law for zoning purposes on a local government level. There's also prohibited uses that will say things like no immoral, obnoxious, or offensive use. I mean, I just hate that one, period. That's back in the old days of wanting to keep, seedy massage parlors out of shopping centers. But I don't know if a declarant or a landlord is going to consider my use to be immoral, obnoxious, or offensive. And so I will also have landlords, especially in grocery anchored shopping centers, that want to amend their declarations to very clearly prohibit marijuana dispensaries, whether those are medical or recreational. Now, if you are representing a tenant who is a cannabis client, they are going to want to know that they can have not only approval for medical, but if recreational is approved in the state of Florida or federally, they're going to want automatically for the lease to allow them to also sell for recreational purposes, because they do not want to risk having to come back and have a landlord say, you can sell for medical, but you can't sell for recreational. And I know a lot of landlords who do in fact take that position. When it comes to rent payments. So remember, if you are a landlord, the minute you take rent from a cannabis company, you are technically violating federal law, because you are receiving the proceeds from a known federally illegal company. And that is also true if you're a broker who is accepting commission from a cannabis company, because you too are receiving funds from a known federally illegal company. And so rent payments can often be tricky. Florida prohibits percentage rent payments, so you won't be able to have percentage rent in there. Another thing to be careful of is some some cannabis companies have gotten in a little bit of hot water when they have bought space out and then subleased a portion of that space to a doctor who was going to write recommendations for cannabis. And they gave that doctor a very sweet deal. So do not allow a doctor to rent space from a licensed medical marijuana treatment center in the state of Florida for less than fair market value, because it's going to start to implicate some of Florida's laws, like Stark and anti-kickback laws that prohibit the exchange of a thing for value by doctors and cannabis companies. Kickbacks is essentially what it's trying to prohibit. When it comes to TI, so any landlord or tenant improvements, I have some landlords who say, I will not make improvements on behalf of a tenant because I don't want to be doing anything that further aids and abets a criminal or an illegal activity. But if you're a landlord at that point, you're already aiding and abetting, you're letting them in your space. So, some just want to minimize that risk by not doing any improvements for the tenant. And keep in mind, if you are leasing space, which is often not the case, usually tenants are buying out space for cultivation or processing, but TI improvements can be huge. So you want to make sure you really understand what that build out's going to look like, because it can fundamentally change the nature of that building. Early termination rates. I have seen the king's scroll length of early termination options in some leases. Some landlords want every out, whether it was, a former president tweeting that they were going to go after the cannabis industry, to just an indication that there could be a crackdown on the cannabis industry. They wanted them out in 3 business days or 10 business days, and they got nothing back but their security deposit, basically. So no damages for the tenant. So I've seen a lot of early termination rights. So just something for the landlord to consider. Indemnification. Some landlords say, I want you as a cannabis company tenant to indemnify me against any criminal prosecution that might happen. All right, well, just by the way, if you are getting prosecuted, that indemnification means nothing. It's not as if you can go in front of a prosecutor and say, well, you can't put me in jail because my cannabis tenant told me they'd indemnify me. Really, that's just maybe you're going to get them to pay your bills. Title insurance. So I've worked with a lot of title companies. For the most part, a lot of national title insurers will not underwrite transactions that involve or may involve marijuana. So if it is going to be selling property to a cannabis dispensary, a lot of title companies will not underwrite that. Or if it's property being sold for land for cultivation and processing facilities, they will not underwrite that. And if they do underwrite it, they're going to put a Schedule B2 exception that says, we as the title company are not insuring against federally illegal activity, which, by the way, all of us know that, right? Like, none of us look at title insurance as a get out of jail free card, but they put that as a Schedule B2 exception. So just know that if you are going to find a cannabis a title company that will underwrite cannabis, like Westcor, Alliant, Stewart, there's some that will do it on a limited basis. So if you ever, or Caddick is another one. So if you need anybody who can underwrite, you can always feel free to reach out to me. Even if they will underwrite, a lot of title companies will not act as escrow agents. So you'd have to go find an outside escrow agent for that transaction. Banking, we've already talked about having some problems on actually finding a bank. And then lending and collateral for loans. So keep in mind, if you are lending to a cannabis company and say, I'm going to lend for them to build out a processing facility. Well, if this was a restaurant and I was the lender and you defaulted, I would just come in and take all your restaurant equipment, and that would have value. But if you are a cannabis company and you default, I cannot come in and now start taking all of your cannabis plants or your cannabis processing equipment, because then I could implicate myself and be in violation of state and federal law as the landlord, because I wouldn't be licensed to have any of those products under state or federal law, obviously. So you got to be careful if you're actually lending in that industry. And those loan agreements are very specific to that type of transaction. Just for some edification, ICSC put out this report on consumers open to cannabis-related shops and retail centers. About 55% said they would welcome the presence in dispensaries. 57 generally have a favorable view. 57 would welcome the presence of CBD shops. So when you see CBD shops, which are popping up everywhere right now, those are, remember, hemp CBD shops, different. Those are federally legal. Doesn't mean that they are FDA approved, the products that they have, but those are not de facto illegal like a CBD derived from marijuana shop would be. Under the shopping center visits, you'll see that some say they would be more likely to visit it if it had a dispensary or a CBD shop. A low amount would be less likely to visit. And then it's pretty much more a higher amount for those who are neutral, has no impact on whether they would visit or not. U.S. cannabis retail sales, you can see some of these estimates pretty high in the tens of billions of dollars that we're going to get to ultimately in this market. It is a huge market already for medical, huge market already, especially for recreational. But you can see up in 2023, we might get to the $30 billion mark. When it comes to other industries, how they stack up against cannabis, wine is doing much better than estimated total demand for recreational cannabis is, but we are beating out pizza at this point, unsurprisingly beating out gym memberships, and also beating out Taco Bell. So not sure if there's a correlation between those two, but you can see that the demand for recreational cannabis is really quite high. And this gives you some retail sales that were estimated in 2019 for markets. Florida, if we had recreational 450 to 550 million, it's presumed that it would be much higher than that now. I mean, we're already in the presumption that we're going to get into the billion-dollar industry for just medical alone. So here's some myths versus realities, and I'm far ahead of my time. I actually have consciously slowed down in the last 15 minutes so that I wasn't going to put myself too far above the hour, but I also want to be respectful because I know you all have a lot of other stuff to do, so we could probably get through Q&A pretty quickly after this. Florida MMTC's myths versus realities. This is the myth. You may have seen something like this on the West Coast. You may have been in something like this before, bars on the windows, kind of tawdry, neon signs. That is not what they look like here in the state of Florida. These are the types of the designs that you're going to see. This is Tedrow, now branded as Parallel. Very clean build outs. Here's some grow operation myths. This is someone's garage that got busted. That could be your kid's closet. And this I liked on Amazon. It's like the new age house husband or housewife who stays home and cleans, and I just grows cannabis right there in their laundry room. So you can get this online if you are so interested, but I will tell you it is definitely illegal. Home grow is not allowed in the state of Florida. So unless that is a hemp plant, which still a question as to whether that would even be legal based on the zoning of your property, probably shouldn't be using that here in the state of Florida, but the operations are massive. So the build outs of indoor grow facilities, this is obviously not in Florida, so you can see mountains in the background, but these are facilities in other parts of the country. Florida is going to get to the ones that look more like the bottom left corner, very significant, large indoor, nearly identical to a lot of industrial spaces. And some are even using former industrial spaces, like out in Lakeland, the Sealy mattress factory was bought out. That old plant was bought out by a cannabis company and retrofitted. And they are truly state of the art. You can imagine that there is a lot more dollar value in each bud on a cannabis plant than there is a rose bud in any rose cultivation facility, indoor or outdoor. So it is huge margins that you see on the cannabis industry. For products, here's some of the myths. Remember, these look super fun. Probably not going to see this in the state of Florida just yet. Here's the reality. You do have edibles, but you'll see a lot of things like sublingual drops, transdermal patches, tinctures, vaporizer cartridges, nebulizers, lotions. I mean, there is a whole host of different types of medical products that are out on the state of Florida. But keep in mind that consistency can vary because it's a plant-based medicine. So, the Blue Crush or Girl Scout cookie type of strain of cannabis you might get at one dispensary could be very different than what you get at another dispensary because they are all growing them differently. Here's a myth on users. This is the Cheech and Chong, and I just Googled pothead and that kid came up. So I'm sure his dad and mom are very proud of that. But these are the types of myths that people think of when they think of cannabis users. But really in the state of Florida, there's folks that have a lot of need that I've met over the years, a lot of veterans and folks with cancer and epilepsy and some debilitating illnesses that have really benefited from this industry. Happy to answer any questions you all have. I appreciate your attention. I just hope that your question is not for me to repeat everything I just said. So if it is, I can talk to you offline about any specific questions you might have, but I'm happy to open up the floor for any Q&A.
Just unmute yourselves to ask the question, please.
Hi, I'd like to know if somebody's interested in buying land here in Lee County for future use of having a business and not medical marijuana, but it would be the recreational in the future. What would be the best way to start looking for that for a client?
So if you're talking about purchasing that land for recreational cannabis cultivation in the future,
Yeah.
so it's It's unclear whether and what those regulations would be. So I have a lot of folks who will ask, what can I do to get ahead of the curve for recreational? I don't know if the regulations are going to say recreational requires indoor grow or outdoor grow. If it was recreational under the latest ballot initiative that was proposed in the state of Florida, then it would be medical marijuana companies cultivating for recreational purposes, which is all indoor as well. So unless it changed and outdoor grow was allowed, that's, it fundamentally alters the decision on that one. So if we could have outdoor grow, then you want land very different than if it's going to be indoor only, because outdoor, I'd say go get a phase 1. You need to make sure that you have soil and water testing done so that there's no contaminants that are going to be sucked up into the roots of the plant and then go into the plant itself, because it's for medicinal purposes. And so you don't want people smoking or ingesting any type of product that could have pesticides in it or any of those other contaminants that are unsafe for human consumption. If it's for indoor cultivation, I don't care what the soil is like, because we're going to bring in all of our own specific soil to be cultivating indoors. If it's for hemp, the same consideration applies, because hemp is grown for, even if it's for industrial purposes, the state treats it as if it's going to be for human ingestion right now. So you would still want to go through that environmental analysis on the front end to ensure that the property is safe for cultivation of any product, whether it is hemp or whether it would be recreational cannabis if that were allowed in the future. Something to keep in mind too is I'm talking about that from a standpoint of Florida law. So unclear what could happen federally. A lot of people are like, oh, the Biden administration, marijuana is like basically legal already because of that. It's not true. And there are a lot of iterations of what federal changes could look like. I mean, it could be decriminalization, full legalization, rescheduling, descheduling, right? So we could take it from being a Schedule 1 drug and maybe make it a Schedule 5 drug, similar to things that you could easily get from a CVS or a Walgreens. Or maybe we deschedule it entirely and it's not regulated at all like you have Schedule 1 through 5 drugs. And maybe now it's a nutraceutical and the FDA regulates it that way. So when we talk about federal changes, there are a plethora of ways that that could play out, and then what the state's rights to implement those programs would look like. So it's really hard to say what recreational is going to look like and what regulations would come along with it.
Okay.
Sorry, it's been a long way of giving you an answer that did.
Thank you. Thank you. I understand.
Hey, Susie, if the law changes, I'll be happy to chat with you then.
Okay. Thank you.
Let's see. I think there's some.
When it comes to the setups for your dispensary, I notice in other states they don't allow you to have a dispensary in adjacent to maybe a alcoholic beverage bar, or perhaps the conjunction of those two. What is the true premise for that, and why do they avoid those kind of interactions?
Right. So local zoning typically looks at public health, safety, and welfare. The bulk of what I do day in and day out, I spend my very exciting Monday through Thursday evenings in public hearings all over the state of Florida. And so anytime people are like, you're not in a hearing at 7 o'clock at night, I'm like, no, that's what time they start here in, insert jurisdiction's name. So most local governments, when it comes to zoning, they look at public health, safety, welfare. So if it's a sensitive use, right, we don't want adult bookstores and strip clubs and packaged liquor stores and bars and nightclubs next to daycares and playgrounds and churches and schools. That's just been a pretty traditional model of having setbacks from those types of sensitive uses. And that was replicated in the beginning with a lot of how local governments looked at dispensaries. And so before 2017, statutory law said local governments could come up with those types of regulations, right? You could determine the number, the location, and other reasonable permitting requirements for dispensaries in the state if you were a county or a city. And so some counties and cities said, okay, you can come in, but you have to be this far from schools and this far from churches and this far from daycares. And those regulations, if the local government has not changed them after 2017, can stay in place. If a local government enacted regulations to allow a dispensary after 2017, when those regulations went into place, they have to comply with the new regulations, meaning they can ban a dispensary or they can treat it like a pharmacy. So if a local government came up with regulations like you enumerated after 2017, that means the pharmacy would have to be treated the same way and they would have to be set back, not existing ones, right? Those would be grandfathered in, but any new ones that wanted to open would come up and have to face those same exact regulations. So the whole point of keeping it away from those other uses like schools is just because they want to keep, vices essentially away from vulnerable populations like kids.
I'm looking to do edibles, not in the state of Florida, but maybe in the state of Wisconsin. So I was also curious as to restaurants. Do they have that same prohibition when it comes to bars to restaurants, where they can maybe make meals or different cuisines around marijuana?
So, good luck. Sounds fun. I am not sure what the rules in Wisconsin are, but let's just say that you were going to be in the hemp industry in the state of Florida and you wanted to create CBD infused food products. So, you know, CBD that comes from the hemp plant, not from the marijuana plant. You would be regulated. Would have to have a food permit to operate and sell anything at retail here in the state that's for human ingestion, whether an ingestion is smokable or
I have,
regulations are just different.
I have a question on that. I just wanted to be clear. Basically, you don't have to grow it in order to do edibles.
So no, you do not. So in this, if we're talking about hemp, I can't see who's asking that question, but if we're talking about hemp, then no, you do not actually have to cultivate the hemp. But if you are going to put CBD that somebody else cultivated into a food product and retail it in the state of Florida, you need to comply with Florida's regulations. And that CBD had to have been produced in a facility safety standards. So it would have to come from something called an approved food source, because what the state of Florida doesn't want is we have a really strict program and then everybody is going to just buy really unsafe CBD from other states, ship it into Florida and put it in our food products as a way to circumvent our strict regulations. So we have very strict regulations and you have to comply with them. So an approved food source is the only place that you can get CBD to put into food products if you're retailing them in the state of Florida. If you're putting it into lotions, that's regulated differently. And there's really not a lot of regulations, unfortunately, in the state right now, if it's not.
Is there a website you can see who are the approved food? I guess you can purchase that from?
No, I don't believe that the state has put that up yet. Now, there is a really friendly user-friendly website that FDAX has. So if you just type in on Google FDAX, FDACS, FDAX and hemp, it'll bring up the hemp and CBD portion of the website and tell you everything about cultivating hemp, processing and retailing hemp, or selling seeds or whatever else you might want to do. So you would need a wholesale or retail food establishment permit if you are going to put CBD into any products and sell them in the state of Florida.
Okay, thank you so much.
Anybody else? I think maybe somebody asked about some of the largest. If you look at the largest companies, I mean, if you want to just see by sale numbers, that table I gave you, which is from the Department of Health weekly update, will show you what some of the largest are. I mean, right now, TruLeaf is the largest company in the state of Florida and arguably one of the most profitable cannabis companies in the United States. So depending on the company you're looking for, I don't give financial advice on what to invest in, but there's a lot of websites out there that do track how cannabis stocks are performing on the different stock markets that they're currently being exchanged on. Anybody else? Remy, do you have a question? Are you typing it?
Yes, no, I can. Good afternoon. Very great information. One thing that I may not have heard it or may not came up, residential leases and medical marijuana. If a property manager, we have our due diligence when we cannot discriminate. So that's a fine line in between. So what are the laws for residential tenants that claim to have medical marijuana card from the doctor, yet quote unquote stink up the whole place?
Yeah. So there's not a good number of case law issues on this just yet in the state of Florida, right? A lot of other mature markets have a ton of case law on this, and a lot of those claims get brought as nuisance claims ultimately. Now you can see I brought this section back up under Florida Statute 381-986. It says that it doesn't impair the ability of any party to restrict or limit smoking or vaping marijuana on private property. So if this is private property, you can have those restrictions. It's the same reason you saw Disney put up those restrictions. It's the same reason you see hotels putting up those restrictions. So oftentimes it'll just be a general prohibition on smoking and vaping. And a lot of landlords will do that because they don't want to get into a bad PR of, you're not going to allow my sick kid to use medical cannabis on your premises, you know, and then they're getting terrible reviews and there's like a whole social media campaign against them. So a lot of private property owners will just say, no smoking, no vaping anywhere on the premises. And that's a way of covering them from both tobacco as well as marijuana products. Some other places. Illegal.
Okay, my leases have a standard clause, no smoking on the premises.
Mhm.
So
Yeah.
that would include marijuana products.
That is enough to include that, yes. Now, I will tell you, the other cannabis products, they don't have an odor, right? I mean, there's not.
No, I understand that part. I'm not against medical marijuana or any of those products. It's just if you have a multi-unit complex and one tenant says, well, I'm raising kids here at the next door, they're vaping so hard, I get high on secondhand smoke.
No,
I mean, that's a nuisance.
when you smoke cannabis, it produces a very distinct and strong odor. So there's not a lot of getting around that. So I don't blame private property owners, hotels, anybody else for not wanting to have cannabis or cigarettes smoked on their premises. And so most of the time the leases will contain that type of restriction that it's just not allowed.
All right. So I can give them a memorandum out and said as of immediate effect, no more smoking weed on the property. All right.
Going to statute 381-986 and tell them you are allowed to restrict it on private property rights.
So what was the statute again?
381-986.
381-986.
Yes.
All right. Thank you very much. That's good information.
Anybody else? I'll let y'all go a couple minutes early if nobody else has other questions, and happy to answer them if you want to email them to me or follow up afterward.
Thank you.
You're welcome.
Okay, any more questions for Tara? If not, we will go ahead and end this presentation, and thank you again so much for being with us here at RPCRA. We really appreciate you taking the time to bring us this valuable information.
Thank you so much.
Thanks.
Thank you.